Hi, I'm Alder from Alder IP, and welcome to another episode of IP. What I wanted to talk about today was the top 5 patent mistakes that entrepreneurs and startup companies always seem to encounter. And number one is making sure that you file your patent before you actually disclose your invention to the market. This is really important. If you disclose your invention before you file a patent, your patent is no longer novel, and the Patent Office is going to reject your patent based on your own prior disclosure of the invention. Also, by disclosing your invention before you filed a patent, you're also letting people know that what the invention is and how it works before you're actually told even the Patent Office, which is kind of a bit of a crazy situation. We always encourage people to file early and file often. If you've got a new invention, you really need to file that invention before you start talking to people, and particularly before you start talking to people who are going to give you input into your invention. You want that invention to be yours, and if you want to claim that, you really want to file that early. The second mistake that people often make is trying to sell their inventions before they've actually filed a patent, which sort of gets back into this whole disclosure idea. If you've sold your invention before you've filed the actual patent, that counts as a disclosure again against your invention and will stop you from filing a patent in the future. And it's really critical that you file that patent before you start making money out of it, before you license it, and before you sell it to others. There's a case in Australia where an inventor actually sold a pen, and the single sale of the pen disclosed his invention, even though no one actually knew how the pen worked. The third mistake that entrepreneurs and inventors often make is they file a provisional application themselves, and the description is kind of on the poor side, it's kind of on the light side. With you filing a provisional application at least has to be 20 to 40 pages long. If it doesn't include 20 or 40 pages of description, it's really not going to disclose your invention to the point where the Patent Office is going to be happy with it. And they're going to reject your application, not now, but in 5 years' time when you're actually making money out of the invention. So it's really of critical importance that you make sure that either your disclosure that you give to the Patent Office has enough detail to support your invention, or that you go to a patent attorney and get them to write up the specification properly for you. You can't make a shortcut with this. It really has to be in detail. You really have to go into the detail of each individual feature of the invention. If the invention has little pieces on the side of it, you have to say which is the preferred version, what it's made out of, how you make it, all these little nuances, and you have to really go through a nuts and bolts description of it. Just merely saying this is a new invention and cutting it down to a paragraph, which I've seen people do, it really won't cut the mustard, and you're really cutting yourself short when it comes to patenting. And you won't find out about it until it actually gets to a patent examiner and they reject your invention. Or you go to a patent attorney and they say, well, we can't do anything about it. The fourth mistake that people often make is not doing their homework before filing a patent application or before even commercializing an idea. The number one thing you should do is do your homework. And really what this boils down to is go have a look on the internet, see whether your invention exists, and check whether you are actually the first to market. Quite often we have inventors come in, and within 5 minutes of looking on a Google search, we've found their invention. So really what you should be looking at is you should be looking at Google really broadly and looking and see whether your invention exists. The other one is also you should be looking at Google Patents. And Google Patents is a subset of the normal Google database, and it just focuses on patents. Now what you've got to remember is a lot of inventions get filed, and not a lot of them end up in markets, or they end up in markets where they're not available in your particular country. So quite often the database in Google Patents is much more substantial than what you could find just by a Google search. The trick is that quite often Google Patents is quite hard to search, and sometimes people use really confusing terms to file their inventions. Particularly patent attorneys. Look, we're guilty of it, and we describe things in very confusing terms. For example, a pen is not a pen, it's an ink deposition module. So if you're looking for it in the Google database, you'll be looking for an ink deposition module and not so much a pen, because patent attorneys don't know what a pen is. If you use a patent attorney, get the patent attorney to do a search. They can do a search as well, and it's not a bad idea. They might not find everything, or it might do even a cursory keyword search. It's not a bad idea. The other thing is also when you file a provisional application, in Australia at least, you can actually get the Patent Office to do a search on the provisional application and they will keep that search result secret for you. So it's just between you and them, which is an ideal way of checking whether your invention actually has the wherewithal in terms of novelty and being inventive. The fifth point is not using a patent attorney to file your draft provisional. And look, I reinforce this. If you don't know what you're doing, you really should be talking to a patent attorney to draft your provisional. They'll give you a quality provisional application, and I know of a lot of inventions that have fallen over and a lot of industries that are worth millions of dollars that have been lost simply because the inventor didn't have the money at the time to file through a patent attorney and file the patent himself. Particularly in Australia, many of the medical device companies have learnt this mistake the hard way. I've worked for 3 different medical device companies and all of them have lost IP from inventors filing their own invention and not going to a patent attorney. And for the sake of saving a couple of $1,000s, they've lost 400 million plus on each one of those inventions. So it's really critical that you go talk to a patent attorney, even if it's just to get some ideas. In summary, just to recap, the top 5 mistakes that entrepreneurs and inventors often make are: number 1, they disclose their invention too early, before they've actually had a chance to file a provisional application. Number 2, they've sold their invention before they've actually filed the provisional application, which destroys the novelty in their invention. Number 3, they file a poor provisional application that doesn't describe their invention. Number 4, not doing their homework properly and doing a proper patent search before they actually file the invention or commercialise their invention. And number 5, not going to see a patent attorney to actually get your provisional patent drafted properly in the first place. They're the top 5 mistakes that inventors often make. If you need anything else, please contact me on the links below. I'm quite happy to answer any of your queries. My name's Anthony Alder and I'm from Alder IP. Thanks.